Third meeting of the Pennsylvania Public Utility Commission for the year 2020, and I ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. As always, we'd like to mention the safety information that is on the inside of today's agenda cover. We also would like to mention and acknowledge that the Commission will act on various matters at today's meeting, which is open to the public. However, since adequate forums have been made available for public participation in cases before the Commission, there's no opportunity for the public to address the Commission at this public meeting. Our first matter on this morning's agenda is the approval of the minutes for January 16th, 2020, and I call upon Commissioner Coleman, who is the editor.
Thank you, Madam Chairman. I've reviewed the minutes of the January 16, 2020 public meeting, and I move that they be approved as presented.
You've heard the motion to approve the minutes. Is there a second?
Second.
Second by Vice Chairman Sweet. Any discussion or further edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. And now we will call upon our Secretary, Rosemary Chiavetta, to lead us through this morning's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Good morning.
Your bureaus and offices have prepared the following agenda for your consideration. Therefore, let us begin on page 1 with the recommendation of Director Monahan and the Bureau of Audits that the Commission release the Management Efficiency Investigation Report and Implementation Plan of the Newtown Artesian Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2, in matters presented by Director Sophie and the Office of Special Assistants, it is recommended in an omnibus motion that the Commission adopt both items on page 2, beginning with the complaint of the Bureau of Investigation and Enforcement versus Tribes, Inc., LLC, and continuing on page 3 to include and end with the joint petition of CenturyLink and Altice Mobile.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Place. Any discussion?
Chairman, I'm going to be voting and concurring in result only on the Bureau of Investigation Enforcement and the Tribe Inc. LLC item only.
Thank you, Commissioner Coleman. Any further discussion?
Chairman, I'll be voting in concurring result only on the matter.
Thank you very much. Any further discussion? Okay. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0, noting that for the case of the Bureau of Investigation and Enforcement versus TRBZ, Inc., that Commissioners Coleman and Yonora are voting in result only, concurring in result only.
Turning to page 4, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt the proposed order in the petition of PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Yonora, second by Commissioner Coleman. Any discussion?
Yes, I have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before the Pennsylvania Public Utility Commission is a letter of notification of PPL Electric Utilities Corporation to construct a new sections of 230 kV transmission line in Salem Township, Luzerne County, Pennsylvania. The new sections consist of 2 double-circuit segments that will split the existing Montour-Susquehanna 230 kV transmission line and Montour-Susquehanna T10 230 kV transmission line and will be routed to the proposed Glenbrook 230-69 kV substation. Also before us is the petition requesting the commission find that a building to shelter control equipment at the proposed Glenbrook substation in Salem Township, Luzerne County, Pennsylvania, is reasonably necessary for the convenience or welfare of the public and therefore exempt from any local zoning ordinance. I support denial of the lawn and zoning petition for the reasons set forth below. The above referenced facilities consist of constructing 2 sections, each approximately 0.5 miles in length, of new double-circuit 230 kV transmission line for an approximate cost of $7.2 million. The cost for the larger project, including the Glenbrook substation and associated 69 kV work, is approximately $65.7 million. Construction of the proposed project is anticipated to commence in fall 2020 with a proposed in-service date of winter 2021. These facilities are being planned to mitigate multiple violations of PPL's FERC Form 715 planning criteria and are not, per se, NERC violations. PPL's FERC Form 715 criteria and operation by PJM can extend NERC and PJM planning criteria to lower voltage facilities, in this case to 69 kV transmission facilities. Extending NERC or PJM planning criteria to lower voltage facilities can have a significant impact on the need for additional transmission facilities, some of which may not be justified based on principles of economic efficiency and should be closely scrutinized accordingly. In this case, both thermal and voltage planning violations occur by extending bulk electric system planning of PJM criteria to these lower voltage facilities. The record in this case, however, demonstrates that events associated with these violations are very low probability. In the previous 5 years, there have been no 69 kV or 230 kV bus tie circuit breaker failures at the Columbia substation and no double circuit transmission tower failures on the Susquehanna-Harwood transmission line. Moreover, the substation facilities involved are relatively new, as reflected in their high operational performance. There are 12 circuit breakers on Columbia substation, all of which have been replaced since the initial construction. The Susquehanna-Harwood transmission line is 51 years old, but as noted above, has had no tower failures in the past 5 years. On the off chance a failure would occur, the thermal violations could be addressed by redispatching generation. This redispatch solution is generally not appropriate for bulk electric system planning purposes, but the decision of PPL to apply more stringent planning criteria to these lower voltage facilities is somewhat arbitrary. Thus, the planning criteria applied here should not necessarily dictate the need for these facilities in all situations. PJM has not reported any PJM nor non-FERC Form 715 violations in the Berwick area. PPL has provided estimates of projected reliability benefits of the proposed project, but the analysis does not represent a risk-adjusted economic cost-benefit analysis, and the projected duration of interruptions are only 15 to 30 minutes. Some of these events could be resolved, as noted, by simple generation redispatch. A first-order cost-benefit analysis using very conservative estimates yields some rather insightful statistics on the economics of this project. On a capital basis, this one investment will cost each residential customer across the entire system $21, or $619 for each Berwick residential customer. On an annual cost of service basis, this would add about $2.45 to the annual bill of all PPL residential customers, or $71 to the annual bill for the Berwick customers benefiting from the potential benefits of this investment. Even more importantly, the money to be spent relative to the Katy, Sadie, and Safety benefits projected by the company are by orders of magnitude much less cost-effective relative to other investments in the company's long-term infrastructure improvement plan. For these reasons, with respect, I will be voting no on this lawn and zoning petition. The company has not proven this project to be in the public interest, as the costs of the project are well in excess of the asserted benefits. Additionally, these filings raise significant issues as to FERC Form 715 related projects and perhaps other instances where PJM and transmission owner planning criteria are being applied to lower voltage facilities that this commission should address. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place.
Continuing on page 4, it is recommended in an omnibus motion that the commission adopt the remaining item on page 4, the application of Honorable Energy LLC, and continue the omnibus to include both items on page 5, both items on page 6, both items on page 7, and including and ending the omnibus on page 8 with the NGS application of Eisenbach Consulting LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Finally, on page 8, it is recommended that the commission adopt the proposed order in the EGS application of Eisenbach Consulting LLC.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yunora. Any discussion?
So I have a statement on the matter.
Commissioner Place.
Thank you very much. Madam Secretary, I ask my statement be placed in the record as if I had read it in its entirety. Before us today for consideration is the application of Eisenbach Consulting LLC for a license to offer, render, furnish, or supply electricity or electric generation services as a broker-marketer to residential, small commercial, large commercial, industrial, and governmental customers in all of the electric distribution service territories throughout Pennsylvania. On January 10, 2020, the Commission accepted the application and subsequently issued a data request for missing or insufficient information regarding the compliance section of the application. In response to the Commission's inquiry, the applicant confirmed that Sandy Eisenbach of Eisenbach Consulting LLC is the same Sandy Eisenbach that was president of Eisenbach Consulting LLC at docket number A 2010-215-7184, whose license was previously canceled by the Commission on October 25, 2018 for failure to maintain financial compliance with 52 PA Code 54.440A and D. In this case, the applicant provided the clarifying information in response to a Commission inquiry and acknowledged it was the same president under the same EGS name as previously licensed by the Commission. In addition, in the denial of Eisenbach's petition for reconsideration of its license cancellation, the Commission accepted that Eisenbach's failure to file an updated bond was unintentional. The Commission also directed the company to file a new application to provide electric generation supplier services as a broker-marketer in the Commonwealth. As directed, Eisenbach has filed a new application for licensure and has clarified the information submitted in its filing in a timely manner. In this particular circumstance, I believe that the company should be provided an opportunity to amend its application with the correct information at the same docket, thereby resolving the matter. Once these steps are taken by an entity, then the amended application can be evaluated by Commission staff and approved if there are no additional areas of concern and the applicant complies with the Commission's statutory and regulatory provisions. These suggested steps will result in the application, supplemental information, and amendments to be contained in one docket. I believe that this consolidated review process provides for administrative efficiencies, both for the Commission and for the applicant, and better serves the public interest. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
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 All those opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place.
Turning to page 9, and matters presented by Chief Counsel Hicks and the Law Bureau, it is recommended in an omnibus motion that the Commission adopt both items on page 9 regarding the rulemaking on Chapter 54 and the petition of Pike County Light and Power Gas Division.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10, in matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt ALJ Johnson's recommended decision in the investigation of West Road Bridge.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Unora, second by Vice Chairman Sweets. Any discussion? Hearing none. All those in favor say aye. Oh,
Sorry, Sunoco?
no.
Oh, sorry.
First item.
I'm moving a little rapidly.
Like
Thank you. All
Like
good.
I did last time. That's okay.
My fault.
All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt ALJ Barnes's initial decision in the complaint of the Bureau of Investigation and Enforcement versus Sunoco Pipeline, AKA Energy Transfer Partners.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Unora, second by Commissioner Coleman. Under discussion, I do have a motion, so I'm going to ask Vice Chairman Sweet to preside.
Thank you, Madam Chair, and you're recognized for the purposes of offering your motion.
Thank you very much. I ask that my motion be spread into the record in its entirety, although I'm going to read the whole thing for you anyway. On December 13, 2018, the Bureau of Investigation and Enforcement filed a complaint against Sunoco Pipeline LP alleging violations of federal and state gas pipeline safety regulations stemming from the April 1, 2017 corrosion related to leaking of highly volatile liquids, or HVLs, of ethane and propane from the Mariner East 1 pipeline in Morgantown. Before us for consideration is the initial decision approving the agreement entered into by BINE and Sunoco to settle the complaint. The area of the settlement that I wish to focus on is the remaining life study that the parties have agreed should be carried out by an independent pipeline expert. The study will, among other things, provide remaining life calculations for the pipeline by 1 segment, 2 age, 3 coating type, and 4 soil conditions. The information collected in this study will be invaluable for any determinations regarding the operations of Mariner East 1. Because of the importance of this study, the independence and expertise of the entity chosen to conduct the study is critical. The process agreed upon in the settlement for choosing the expert is that Sunoco will provide BINE with a list of 3 experts that have conducted studies for, but not limited to, the Pipeline and Hazardous Materials Safety Administration, other state commissions, the Pipeline Research Council International, the American Petroleum Institute, or the Interstate Natural Gas Association of America. The settlement provides that within 30 days of entry of the order approving the settlement, Sunoco is to forward a list of the 3 experts to BINE. With this motion, I clarify that BINE shall select the expert to conduct the remaining life study within 30 days of receipt of the list. The settlement also states that any work done by the expert on the Mariner East 1 pipeline must be disclosed. For purposes of transparency, I believe that adding a provision requiring disclosure of any projects this expert has worked on for Sunoco's parent company, Energy Transfer Partners, or any Sunoco affiliate should also be required and furnished to BINE in accordance with the provisions of the settlement agreement. The settlement provides that Sunoco is responsible for paying for the remaining life study. To further ensure the independence of the study, I believe that only the final form study, not the interim drafts, shall be delivered to Sunoco and BINE on or before the end of the agreed-upon 6-month contract. I believe that these modifications will ensure a transparent and objective process. With these controls put in place, I am able to support the settlement agreement as being in the public interest. Therefore, I move that One, the initial decision of Administrative Law Judge Elizabeth Barnes dated March 16, 2019, be modified consistent with this motion. Two, the Office of Special Assistance shall prepare a tentative opinion and order approving the proposed settlement agreement as modified by this motion. And three, if no adverse comments are received within 10 days of entry of the tentative opinion and order, the modified settlement agreement is approved.
Thank you, Madam Chair. Is there a second?
Second.
Seconded by Commissioner Place. Excuse me. Is there any further discussion? Commissioner Place, you have a statement?
Statement on the matter. Thank you.
Recognized.
Thank you. Madam Secretary, I ask that my statement be placed in the record as if I had read it in its entirety. Before us today for consideration, as noted, is the initial decision of Administrative Law Judge Elizabeth H. Barnes approving the joint settlement agreement addressing the Bureau of Investigation and Enforcement's complaint against Sunoco Pipeline LP, which alleged violations of federal and state gas pipeline safety regulations regarding a leak of highly volatile liquids of ethane and propane from the Mariner East 1 pipeline in Morgantown, Berks County on April 1st, 2017. The joint settlement agreement was filed with the Commission on April 3rd, 2019, with a subsequent amendment filed in June 2019. The matter, including responsive pleadings, was referred to the Office of Administrative Law Judge, and substantive comments were filed by several interveners. No exceptions or replies were filed to the initial decision. While I concur with the ALJ's approval of the joint settlement agreement, I remain concerned about one provision. The agreement directs that a remaining life study be completed by an independent expert, as noted, within 6 months of being contracted to perform the work. The agreement also directs that a summary of the expert's findings shall be made public, excluding, of course, proprietary or confidential security information. I would have preferred that all of the expert's findings be made public in a redacted version, with the same caveat that no proprietary or confidential security information remain in the document, not, as stipulated in the agreement, simply a summary. I believe that a redacted version of the expert's full report findings would provide more transparency and additional information about the remaining life of ME1. I support the initial decision approving the joint settlement agreement with this one articulated reservation. Thank you.
Thank you, Commissioner Place. Is there any further discussion on the matter? Seeing none, all those in favor of the chair's motion will signify by saying aye.
Aye.
Aye. Opposed? The vote carries 5-0. Is there any objection to using the same roll call for the vote on the matter as amended? Seeing none, the matter as amended is approved 5-0. Thank you, and Madam Chair, I turn the gavel, except I never took it, back over to you.
Thank you very much.
Turning to page 11, it is recommended that the Commission adopt ALJ Calvelli's initial decision in the formal complaint of Linnaeus and Gina Whitehead versus Verizon, Pennsylvania.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion?
I have a motion, Madam Chair.
Vice Chairman Sweet.
Thank you.
Yes.
This case involves the dismissal without prejudice of a complaint filed by the Whiteheads against Verizon, Pennsylvania. The Whiteheads averred that according to a contractor they hired to repair a backed up sewer line, Verizon had drilled through that line, causing the damage. Following further preliminary activity, the Whiteheads filed a petition to withdraw the complaint without prejudice, advising that they had reason to believe another party was responsible and wished to pursue that party with permission to refile if new information implicating Verizon became available. The administrative law judge reviewed the petition, Verizon's lack of objection, and the public interest. He concluded the petition should be granted, stating that granting the request will save the parties and the commission time and resources and will not impact the public interest. With that, I agree. However, in prefacing his conclusion, the ALJ stated, quote, "The complaint does not allege facts that would impact the public interest. No public interest would be served by litigating this case. There can be no public interest affected by granting, close quote, the petition without prejudice. The quoted language could be misleading. The complaint alleges an issue with public utility service and thus does allege facts that could impact the public interest. If the ALJ believed that a case involving service to only one customer cannot ever implicate the public interest, as the language quoted may suggest, that is incorrect. The fact that it involves one party is but one factor to consider when evaluating the impact on the public interest. This is particularly true for a matter for which we are allowing withdrawal at a preliminary stage. To satisfy our regulation in this case, it is sufficient to conclude merely that under the circumstances, the request to withdraw is reasonable and in the public interest. Therefore, I move that number one, the initial decision be amended consistent with this motion. Number two, the initial decision be affirmed in other respects and withdrawal without prejudice be permitted. And thirdly, the Office of Special Assistance prepare an opinion and an order consistent with this motion. Thank you very much.
You have heard the motion of Vice Chairman Sweet. Is there a second?
Second?
Second by Commissioner Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? Seeing none, on the matter as amended, passes 5-0.
Continuing on page 11, it is recommended in an omnibus motion that the commission adopt ALJ Long's initial decision in the complaint of Gary Mandikik versus West Penn Power, and continuing to include both items on page 12, ending with Special Agent Arnold's initial decision in the formal complaint of Terrence Gray versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Yonora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that concludes the regular agenda. Turning to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Bureau of Technical Utility Services that the Commission adopt the proposed order in the tariff supplement filing of UGI Utilities.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Sweet, second by Commissioner Coleman. Joint seconds by Commissioner Coleman and Sweet. All those in favor say aye. Not Sweet. I'm mixing it all up.
So I'm causing the problems here.
All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
Turning to page 2 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order in the petition of Verizon Pennsylvania and Verizon North.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yonora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items for consideration today.
Seeing that there's no other business before the commission, is there a motion to adjourn?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Yonora. I assume everyone is in approval. All those in favor say aye. Aye. We are adjourned.